Mr. President, I appreciate the passion the remarks provided by my friend and colleague, the distinguished senator from Delaware. I do feel the need to respond to a couple of things, and a couple of things that have were said previous to that by the senator from Michigan. With regard to the senator from Delaware, there are a number of claims made that are very serious, and because they're very serious, they need to be responded to immediately. She used terms like poll tax, Jim Crow 2.0, talking about adding costs as if we're charging someone to be able to have ballot access, to be able to vote, which would be a poll tax. We ended that some 60 years ago by a constitutional amendment. This is not that. Not only are we not charging someone to vote, we're not charging someone to register to vote, nor are the documentary requirements in place anything that would cost any individual any money at all. They need not cost them a single penny. Because even if you don't have every document that you need in order to establish citizenship, something that's already required by a whole host of other laws, most familiar to most Americans would be in the labor and employment context, where every time you start a new job as an American citizen in the United States as an employee, you have to fill out an I-9 form, and you have to provide a very specific set of documents to establish citizenship. You may do so with a U.S. passport establishing citizenship. If you don't have a U.S. passport, you may do so with a birth certificate, together with a photo ID. A Social Security card can also come into play, but it's a fairly limited set. What we have established in this bill is far more flexible than that. We've added a bunch of other documents. We've tried to be as expansive and as inclusive as humanly possible in order to do that. And then we've provided a fail-safe that I have yet to hear any of my colleagues across the aisle refer to when making these very aggressive accusations that this is a poll tax, this is Jim Crow 2.0, that this is going to disenfranchise women or people of particular racial minorities. It's just not true. They're ignoring the existence of the provision that begins on line 22, page 12 of the bill, and continues on to the next page, which says that if for any reason, or no reason at all, you don't have the necessary documents, any of them or all of them, you have none of them, you can still handle this by an affidavit that you can write out, thus putting the burden on the state to confirm or refute the underlying facts establishing your citizenship, whether through citizenship through natural-born citizen status by virtue of the circumstances at your birth, at the time of your birth, making you a citizen, or the circumstances that led to your naturalization, if you're a naturalized citizen. That does not cost anyone a single dollar, and it puts the burden on the state to track down the necessary background so that the state can certify you. So these arguments are not only missing the point, they become aggressively wrong. To the point of just being flat out false, demonstrably false. And so we can hear this over and over and over again, but it doesn't change the fact that in the bill, nobody's charged a thing to vote, not one person. And so when we hear about this being costly, that just isn't true. Likewise, another comment was made by my colleague from Delaware, referring to a vote by mail provision, referring to some more sweeping changes that are made in a separate amendment that are not part of this bill right now. This bill has two principal provisions. One deals with establishing proof of citizenship at the time of voter registration. The other deals with photo ID at the time of voting. This one doesn't do that. Yes, and one or more amendments have been filed that would expand that to include some significant restrictions on mail-in balloting, but that is not what's being debated on the floor right now. I've got no objection to anybody wanting to raise those now, given that amendments have been filed, and there's been some talk of this, but just to be clear, the bill on the floor doesn't contain those. I also need to respond to a couple of the more egregious points that were made by the preceding senator, the senator from Michigan. Among other things, she repeated some of the same false accusations that this would somehow disenfranchise married women. It absolutely, emphatically would not. In addition to making it very easy for somebody who's got all the other documentation but maybe doesn't have a marriage certificate backing up the name change, or maybe they're missing all of them. Again, you go back to page 12, line 22. Any person, whether they've changed their name or are missing some of their documentation or all of it, may establish it by affidavit, putting the burden back on the state elections official. The senator from Michigan also made some curious claims with regard to the Constitution, with regard to federalism and the relationship between states and the federal government. Among other things, she insisted that the founding fathers, those who wrote the Constitution and those who ratified it, were emphatic about the fact that they did not want, as she put it, the federal government running elections. Well, there is some truth to that, but her ultimate conclusion is 180 degrees opposite of what the Constitution says and what they did and what the words say. So it's very important for us to do this, to make sure that we're talking about the same things. So if you go to the Constitution, go to Article 1, Section 4, Clause 1. It doesn't talk about it because it doesn't need to talk about the states conducting their own elections for state offices. That goes without saying that the states are in charge of that. But it does talk in Article 1, Section 4, Clause 1, about the fact that the state governments will be in charge of setting up rules and regulations governing the conduct of elections for federal officials. And it also says, right after that, in the very same sentence, quote, "But the Congress may at any time, by law, make or alter such regulations." And that is what we are doing here. Because these involve federal offices, we have the authority to set important terms and conditions specifically for federal offices. It's not that we are encroaching on any constitutional power. This is our power. It may lay dormant insofar as we choose not to exercise it, but it's not currently dormant. And in fact, we've legislated on a number of occasions, and there are at least 4 or 5, maybe 6 major pieces of existing federal law that deal specifically with the state's conduct of federal elections. Separate and apart from another very serious federal criminal penalty that makes it a felony for a non-citizen to vote in a U.S. election. So in all these respects, the Congress can, it may, it is expressly authorized to legislate, and it has indeed legislated. Among other things, it's legislated with the NVRA, passed in 1993. It is the NVRA specifically, and the manner in which it's been interpreted by the Supreme Court and implemented, that necessitates these provisions, specifically the citizenship provisions of the Save America Act. Because but for the Supreme Court's ruling in Arizona versus Intertribal Council of Arizona in 2013, a case decided some 20 years after the NVRA was enacted by Congress in 1993, the court in that case said the states may not even inquire into someone's citizenship, may not require proof of it, even where they suspect that some voters might be non-citizens. Now, that interpretation was wrong. It was contrary to the text, to the structure, to the original public meaning of that statute. It was wrong, but it's nonetheless conclusive. It's a majority opinion of the Supreme Court. It hasn't been overturned, and that's why this is necessary. So to call this a federalism problem, to call this an overreach by the United States government into the exclusive domain of the states is literally not true. Why? Well, because in the first place, the Constitution itself makes it federal, and it's necessarily federal. I would add to that that's even more important here, because this bleeds into another one of the federal government's exclusive powers and exclusive abilities, namely the ability to identify and ascertain the citizenship of any American citizen. That is not the role of the states, nor do the states have the comprehensive databases that the federal government does have. The federal government has the ability conclusively to determine whether or not somebody is a citizen. The states do not, and that's yet another important reason for us to make that determination. It's also relevant that this is where we get into trouble with a number of these, the blue states, the Democrat governors, Democrat legislature states, that are refusing even to talk to the federal authorities who run the SAVE database within the Department of Homeland Security. Remember, it is against the law for a non-citizen to vote in a federal election. And that's why we have these laws and these systems and this database, the SAVE database already set up. And yet a number of these blue states, a whole lot of them, are refusing even to talk to federal authorities, even to share with them what, if anything, that they're doing to make sure that non-citizens are not voting in U.S. elections. This has become a problem of especially great concern in recent years, given that in some states, a handful, at least 4 or 5 states in the District of Columbia, now have in place systems where in some local elections within their state's jurisdiction, non-citizens are openly, by state law, allowed to vote in those elections. Therefore, when they register to vote, they have a voter registration file. Basic questions have been asked of them. How do you differentiate those who are non-citizens who have registered to vote in your state? And how do you make sure that they don't get ballots to vote in a federal election, for example, for a U.S. House of Representatives race or a U.S. Senate race? They have refused to answer the question. They have refused to cooperate. They have hidden these details. These are important details. Details that we have constitutional authority, a moral obligation, and a legal obligation to look into to make sure that our laws are faithfully executed, and they refuse utterly to cooperate. If that's not chilling, I don't know what is. My friend and colleague from Michigan also implied that there is some sort of a de minimis marginal concern about, in her state and in every other state, about non-citizens registering to vote. Oh, it happens every once in a while, somebody gets in there, we remove them. Well, let's remember, I looked up some articles on this, and I've got one right here from a publication called The Michigan Bridge. One of the ways that they found a handful of non-citizens registered to vote was in a sort of haphazard way. They found 15 just by doing something very simple. They compared a list of people who had gone into court after being summoned for jury duty. Jury duty, remember, typically turns on what they call the wheel, a random selection from among registered voters in the jurisdiction. You're called up if you're a registered voter randomly to serve in jury duty. Periodically, in Michigan and in many other states, people will show up for jury duty. There are all kinds of tricks that people use to try to avoid jury duty if they don't want to. This one may or may not be a trick in some circumstances, and in many circumstances it wasn't. People were truthfully saying, I'm not a citizen, therefore I may not, must not, cannot, will not serve as a juror. So somebody came up with the idea, let's compare, I think there were a list of, 250 or so who happened to have made that argument. Then they compared them against Michigan's voter registration database, and they found that at least 15 of those individuals were non-citizens who had registered to vote. That is a far cry from saying that there are only 15 non-citizens registered to vote in the state of Michigan. When you consider the haphazard, random way in which they found this out, one would suggest that not only that there could be more, but that there likely are a lot more, because most people aren't getting called in for jury duty, and most who aren't necessarily invoking this defense of I can't serve, I won't serve, I may not serve because I am not a U.S. citizen. Finally, with regard to the federalism point, I find it very curious that this argument continues to surface, and it surfaces in particular from our Democratic colleagues. And the reason I say that is that all of a sudden they're very concerned about federalism, about maintaining the sanctity of the distinction between that which is state authority and that which is federal. That's important to me. I focus on a few things more than that. I think the core structural provisions of the Constitution, the vertical protection that we call federalism, and the horizontal protection that we call separation of powers, are as important as any other feature in the Constitution. And when we deviate from those, we cause all kinds of ripples downstream. So I'm very sensitive to these issues. I want to avoid any semblance of trampling on state sovereign authority. This, sir, is not that. And especially when we hear this from those who just a few years ago, during the Congress ranged between January 3rd, 2021 and January 3rd, 2023, in which both chambers in Congress were controlled by Democrats, and we had a Democratic president, President Biden. During that time, they supported legislation known as H.R. 1. Now, if you want to see a federal takeover of elections, H.R. 1 was that. It was vast. It was sweeping. It covered all sorts of things that the federal government has no business taking over in elections. Among other things, it would have designated every single voting jurisdiction and the entire United States of America, regardless of what part of the country they're in, regardless of what, if any, history they may have had with past de facto or de jure discrimination or segregation of their state, subjected them all to pre-clearance, meaning anytime they passed any law affecting the way votes were cast, precincts were drawn, or otherwise, they would have to go to a political appointee, a Democratic political appointee inside the Department of Justice, to seek a mother may I, an advance blessing from the federal sovereign before they could make those changes. That, Mr. President, is a violation of federalism, and that is something that, last I checked, every Democrat who now serves in the Senate, who was here at the time, supported. So I'm sorry, count me surprised that they would make the federalism argument now in reference to a bill that focuses solely, exclusively on powers that the federal government does in fact have. And in fact, the only reason this bill is necessary, Mr. President, is because of existing federal law, the way it's been interpreted and the way that it's being implemented. That's the only reason we need any of this. That is not a federalism problem. That, Mr. President, is an appropriate exercise of federal power. We do just as much violence to federalism when we deny to the federal sovereign the ability to exercise federal power as we do when we do the same to the states. Thank you.